So I'm delighted to welcome you to this discussion on AI and inventorship. And we are really lucky to have three excellent speakers. I know we're only seeing two at the moment. One is invisible, and that's part of the AI puzzle here. No, but we'll be joined by the third speaker very soon, shortly. So I'm going to invite Robert Peake to speak first, and then Professor Ryan Abbott will follow up post Robert, and then I will invite Christoph to speak. I'm hoping, if the sequence goes perfectly, that we'll still have about 30 minutes or so for question and answers. I'm also hoping to bring in the new UK Supreme Court decision that's just come out 2 weeks ago. When I have warned my panelists that we will be doing that. So I think this is going to be quite an interesting discussion. I hope you have your questions ready, and this is being recorded, so it will be lovely to have this as a resource. So, Robert, would you like to kick us off with the first 10 minutes?
Sure.
And then, yeah.
Thank you for the intro. So I'm Robert Peake. I'm an IP litigator at Keystone Law. I suppose to begin with here, I've been, myself and my team were leading a permission to appeal application in the Thaler decision. There was a high court decision. This is sort of the second outing in the UK courts for Thaler and DABUS. Ryan can talk more about that first series of cases that went all the way up to the UK Supreme Court. We were dealing with permission to appeal recently from the High Court decision, which refused Dr. Thaler's patent application for what previously had been described at all stages as an AI-generated invention. Ultimately, Dr. Thaler's name then appeared as the individual inventor on the patent, the requisite patent form. Notwithstanding this, the application was refused on the basis that Dr. Thaler had been maintaining for many years that, in fact, he was not the deviser of the invention, which was the subject of the application. So, as I've said in correspondence before this, I came in very much at the end of this. Ryan's been leading this for a number of years, and I think Ryan will be able to go into a bit more depth about what the first series of outings consisted of. But to summarize that, Dr. Thaler came up with a machine nicknamed DABUS. Can't remember what that stands for exactly. Bootstrapping is in there. That outputted some autonomously devised inventions, and a series of patent applications were then filed all over the world for protection of those, ultimately to test the patent systems globally to see where a system will accommodate an AI-generated invention. And by AI-generated, I mean no individual themselves felt compelled to be able to say, I am the inventor of this invention. It was generated by the AI. And I mean, I think we can see now, especially in the last couple of years, when you look at the advances of generative AI in particular. I mean, Ryan was just showing me a video involving Will Smith eating pasta as an example before the talk, and it's incredible. And that, I think, looking at when Ryan started this quite a number of years ago now, I mean, it was really quite prescient. I think when he started, we probably had very little idea that we were going to be sort of in the grips of what we are now with, sort of AI commotion, if you will, where we're seeing all kinds of, I think, previously unforeseen consequences of the rapid adoption of the technology. I think the ability of AI to invent is just one of them, although I think Dr. Thaler would say the AI has been able to invent for actually quite a long time, much longer than many people would expect. I mean, certainly in my line of work, what we've seen is some tremendous consequences of the rapid and, I would say, careless adoption of AI. I mean, the number of court proceedings lines where advocates have been caught out relying on jurisprudence that doesn't exist. I mean, that's incredible. And certainly I have firsthand experience of dealing with these opposing parties who very clearly have been using generative AI and responding with things that I think at first view appear potentially actually quite well reasoned and quite legitimate. And it's really, you need a fine-tooth comb now. That's where the technology has got to in order to be able to identify that something is not actually as it appears. So it's a fascinating space. It's rapidly evolving. I think in the UK, we now have, oh, this is perfect, right on cue. So we have, thanks to Ryan and the Thaler line of cases, we have the definitive answer. There's got to be an individual human inventor in order for you to be able to get protection for an invention. And maybe with that, I can hand it over.
Can I ask you to tell us a little bit more about the second round?
So the second round, we pursued a couple of lines of attack. We differed from the High Court judge and the conclusions there. One question that we had that remained was, can the Patent Office controller, via the examiner, look at extraneous evidence to determine whether or not what is said in Patent Form 7, I mean, it's really getting down to the nitty-gritty of patent prosecution procedure, and the Patents Act 1977, whether or not, looking at the form, the decider can think about anything else that they know, or have heard, or have read. For instance, maybe they've been aware that Ryan has been running a series of cases around the world for 6 years in which Dr. Thaler has said he is not, in fact, the deviser of the invention as far as he is concerned. And so one question we had was, well, you haven't answered whether or not the person sitting in the patent office can, in fact, look to those extraneous sources or their own knowledge and experience, or whether, in fact, it is a pure procedural matter and the form in front of them as it stands is open and shut, and that's it, it's the four corners of the form.
Can I push you a little bit more on that issue? So I think one of the reasons for the second round, keeping with the theme of transparency and fairness, was the claim that if this has been invented by the machine, you would then say that it has been invented by the machine, and the machine should be set out as the inventor, right?
Well, we know that setting out the machine as the inventor will be, that full stop, you're done.
Yeah. So is this just a procedural matter, or is this part of the same question of transparency, where the court is then saying, since you have said that the machine is the inventor, you can't now go back and say Stephen Thaler is the inventor. So is that not in keeping with your own case in some ways?
Well, so 2 points. I think I'll let Ryan comment about the state of mind of Dr. Thaler. But I mean, I would make a point that if Dr. Thaler or anyone else who has the belief that an AI has invented, has devised an invention, applies with their own name as the inventor. I mean, let's just say there's an AI in a lab. There are human inventors. They don't happen to have invented this particular invention. The AI did. Whoever is running the lab, and perhaps anybody else who assisted, maybe whoever provided the necessary background and the inputs for the AI, will name themselves as inventor. And as long as they remain silent, apart from that, it will sail through. It will never be questioned. Dr. Thaler, on the other hand, was quite open and transparent about how the invention came to be. And then the Supreme Court decision came down, and that had an influence on Dr. Thaler's understanding.
Okay, great. So that was kind of a nitty-gritty point which you may have picked up if you've read the decisions, but I think, there's a lot hanging on that particular question. So I think we'll now go to Ryan. And welcome, Ryan. And I hear you've just been at the hearing. So
sadly not a Thaler related one.
Okay, but I'll give you had a few minutes to come back into this room. So thank you for joining us. So I wonder if you can tell us a little bit more about the whole project of testing jurisdictions. Why start that? Why this moment? What is your motivation to do that? I mean, I know there's a lot of information out already, but we'd like to hear from you, given where we are at this point, about the whole project and the value of that project.
Sure, well, it's a long story, but I can
Yeah.
get started, you can interrupt me at some point. But basically, I was working as a lawyer for a biotech company and teaching patent law. And computers were doing more and more, and we had a vendor who came to us and said, if you tell us your therapeutic target, we'll have a computer go through our big antibody library, find an antibody that'll have good binding affinity for you, and you can make that your new drug. And I thought, well, that's interesting, because I don't know how well this works, but it kind of sounds to me like you're having a machine invent something. Because we have pharmacologists do this in front of a bench, doing it 10,000 times, or using mass throughput screening, and here you're just saying you're going to effectively automate it. And who knows how automated it was, but anyway, I started thinking about it. And I wonder if anyone's thought about what happens if a machine invents something. And it turned out people had thought about this since the 60s, and largely said, well, you wouldn't need patents on this because a machine doesn't need a patent. And I thought, well, true, but really inventors don't usually get patents. Companies get patents. And a pharma company needs a patent. Whether they have a machine find a drug or a person find a drug, what does it matter? So I wrote a law review article on it, arguing for that. And people thought it was reasonably interesting, more interesting than anything I'd written previously. And in the course of about a year, drug companies started asking me, actually, we're kind of concerned about this. Like, what do you think we should do? What's going to happen? And I said, I don't know. There's never been a case on it. And why would there be? Someone would be throwing their patent up to get canceled. And people got interested enough. One of my colleagues said, well, we should do a test case on this and clarify the law and see what happens. So we did. So that was basically the gist of it. And at the time, it was really just AI being used like this in drug discovery and industrial engineering, right? Kind of like with copyright, it was done but really academically or very nichely, and now you can have ChatGPT make an image, write a song, or now invent something, right? You can just say to ChatGPT, can you improve this patent application, and write a new patent application, and that's all you need to do now. So this case was a little ahead of its time, but it was designed to do that because, otherwise, why would this matter? It would matter in the US at least, because if you don't have the right inventors, you can invalidate a patent at any point in the patent's life cycle. It's different in other countries. But you would be litigating, Pfizer v. Amgen, and you'd depose an inventor and she'd say, well, we licensed this model from Google, and it told me this new drug would work, and I don't know why it would work, and I don't know how it came up with it, and I didn't test it, but the AI said it would work, and so we gave it to our patent attorneys, right? And in America, for that, you'd lose your drug, or your patent anyway, right? And so we thought it would be a good idea for once to have the law go ahead of technology and get some insight into this. And so the cases were really about whether you could patent something made with AI, and what it means to make something with AI, and what it means to be an inventor, and who or what would own that, and also to make more work for patent attorneys and law professors.
Fantastic. That you certainly have done. How many jurisdictions is it in now?
17.
17. And can you give us a little bit of a breakdown of how the decisions have gone?
Sure, and there's the copyright case, which very sadly the Supreme Court in the US declined today. They'd asked the Solicitor General to weigh in on it. There were multiple amicus briefs. There was a lot of chatter, but they apparently only want cases involving Donald Trump at the moment, which is sad to all of us. Well, let's see. So first we got a patent in South Africa. That was pretty cool. That was 2021. Now South Africa has a registration system. They don't do substantive examination, but inventorship is everywhere a formalities issue, so they did look at it. And the case already survived substantive examination in the UK. Then a week later in Australia, we had a 40-page reasoned decision by the enlightened Justice Beach, who said that yes, you could patent an AI invention, yes, you could name an AI as an inventor, and yes, in our case, the AI's owner had to clear his claim of entitlement to the patent. That was overturned on an en banc decision. The US Federal Circuit tossed it out and said no. I can give you a longer answer, but no is the gist of it. After which the US Patent and Trademark Office went from their earlier position of this really doesn't matter to actually this is kind of a big deal for us. And here's a 60-page guidance with very detailed examples of what you can patent and when, depending on how much an AI does or doesn't. Now the Trump administration came and canceled all that and just said, oh, it doesn't matter if you use AI. But also the USPTO doesn't make the law, they just interpret it, so it's all a little weird. We got to the UK Supreme Court. I was very disappointed in the judgment there, obviously. They said no also. And basically, look, if Parliament wants to change the law, they can go ahead and do that. I thought the UK law was actually very permissive towards this because it doesn't, in preference to an inventor, someone who has entitlement by virtue of any rule of law is entitled to priority to the patent. Owning the property made by your property is a long-standing common law principle, which could have been extended to intellectual property and has another context, but the Supreme Court declined to let that be so. And in the UK, you have to disclose all natural person inventors, and we argued, well, here we didn't have one, and that, we had a claim of entitlement under traditional property ownership rules. But the Supreme Court wasn't having it. But meanwhile, Germany said, you don't have to be a deviser in Germany like you do in the UK, so as long as you have someone with some connection, and Germany and Switzerland and Europe have looked at this now and said, well, owning an AI, using an AI, training an AI, all that's kind of enough. There shouldn't be a bar to patentability. Hence the second application, which was, well, yeah, a machine made this, but someone made the machine, someone used the machine, someone owns the machine. Maybe that's enough to be a deviser in this context. So as it is now, you have the US and the UK which don't allow patents on this. Although in the UK and the US there's very different disclosure issues here, because in the US this will come up, and in the UK you could probably just not disclose it and be fine. In the US you're legally required to disclose it. And then, Europe, which says kind of we don't care about this, go ahead and get a patent. And so you have kind of this major disharmonization right now, which I think is very interesting academically, but problematic commercially.
Okay, great. So I just want to maybe go back to the doctrine of accession that you just raised. Interesting argument. However, when I read that part of what's on your website and using the doctrine, what you're claiming is not just that the fruit of the machine belongs to the inventor of the machine, but you're claiming that through the patent, right? Which is a little different from then just saying that you're going directly from the machine to what the machine has invented. You're actually saying you want not just the invention, but you want a particular kind of title to it, which is via the patent system. So I wasn't convinced that that chain of thought in terms of doctrine of accession actually plays a... I mean, I know the doctrine of accession has been used for the doctrine of equivalence, for instance, right, in patent law. So if you have future technology, it can be part of the scope of the patent. But I'm just curious about, your thoughts on the ownership of the patent in the name of the inventor being part of that doctrine of accession.
Right. I mean, if you're saying, well, the fruit should belong to the AI owner, but not a patent on the fruit.
Yeah.
Right. I mean, a trade secret on the fruit would belong to the fruit owner, right?
Yes.
So if you have some new genetically interesting fruit that you were involved in creating, you'd own a trade secret on that, even though it, comes from the tree. In our case, I mean, the relevant property is simply a patent and not the fruit itself, because, I mean, otherwise you could keep it as a trade secret or confidential information. No one would really dispute that, and that works for some inventions, but not others. But, to have the system work the way it was intended with the right incentives, the thing that you care about in our case is a patent. So to me, part of what was interesting about these cases was whether you want to take a textualist approach to patent law or a purposive approach to patent law, right? And inventorship is one of the least harmonized aspects of patent law anywhere, as this case has shown. Like some places you don't even need to disclose an inventor, like Austria and Israel. Cyprus and Monaco say you can have corporate inventors. But if the patent system is designed to promote innovation, disclosure of confidential information, and commercialization of new inventions, then it works well having AI owners be able to get patents on AI inventions because it incentivizes them to make and use inventive AI, disclose that output, and invest in making it into commercial products. So if you're looking at kind of common law purposive solutions, I think it fits in quite well. Could you kind of decide based on a law that was written in the 70s that it doesn't, literally think about this or deal with it? I mean, sure. And that's what the Federal Circuit found. A law that was much more explicit, inventors are individuals. But even there, the Supreme Court in the US had held individuals don't always mean natural persons. And when you break these things down, their second reason for holding no was, well, a dictionary says an individual is a person. And we said, well, the second sense of the dictionary is or a thing. And they said, well, the rest of the act makes it clear it's a natural person, like an invention can go to an inventor's heirs. We said, yeah, but you're also not supposed to prohibit patentability based on how an invention is made. So there's a lot to kind of pick your lane if you're trying a textual interpretation.
Yeah, I like that phrase, pick your lane. So I'm going to go back to the same point. I'm not super up to date with the disclosure of inventor in US law, but I'm wondering if some of this is about disclosure when it comes to inventive step. The process of reaching that invention, if it works in your favor to get your patent, would be part of how you describe your inventive step anyway. So why take this element of the disclosure to the inventor rather than about putting it into the process of arriving at that invention and strengthening, or I think strengthening your case for achieving an inventive step?
Well, in our inventions, there was no dispute about inventive step, at least not before the UK IPO, which examined them. I mean, compared to the prior art, it was inventive, and it didn't really matter how you got to it. It was just an objective comparison of prior art versus new disclosure, right? I mean, ours was, you could have tried to hedge it, lie about it, or interpret it differently. And in an ex-parte thing, again, no one would question it. I could have put my name on it, and there wouldn't be any test cases, and no one would know about it. But, if we were saying, what does it mean to be an actual deviser? On the facts of our case, that he didn't intend the machine to invent anything in particular, he didn't tell it to solve a particular technical problem, the machine recognized the value of its own output before a person saw it, he wasn't the actual deviser of it. And we were, in fact, really trying to test the law on this. So for us, it was transparent to disclose it in that manner. Now, if Germany says, actually, we don't care about any of that, own an AI, use an AI, train an AI, good enough. Fine.
Okay, that's useful to know. So I'm going to go back to one question that I think I'll pose to both of you, which is again on the website, which is a wonderful resource in terms of keeping up to date with what's going on. You say one of the reasons for this test case is that you want to show that the use of AI is in keeping with the incentive function of the patent system. I wonder if both of you can say a little bit more about that. Is use of AI the sort of thing that the patent system should really be looking to amplify? And is that kind of where we are?
I mean, I don't see why not. It's just another technology, another tool that may well help, frankly, accelerate invention, right? I mean, it helps humans do more and do it faster.
Exactly, so the incentive is for the human behind the machine.
Sure. Can be.
Yeah.
But remember, as Ryan pointed out, those humans, in reality, are usually employees. Right? The fact that it's a human doing the invention, at the end of the day, is neither here nor there, because the human's not going to. Humans, individual inventors, don't have the capital necessary. Now, some people, some proponents of AI will probably say, oh, but it will be possible because, this is going to be technology in everybody's hands. It's not. I
suppose it's a question about the design of the incentive. We've spent 200 years designing the system that incentivizes humans to do certain things. So the question is, how easily does that architecture apply to this sort of amplification of AI?
In my view, it applies very naturally. And again, it's not just incentives for humans. I mean, I think largely, literally, it's incentives for companies, because companies own most patents, right? Because Pfizer is the one who invests in a giant infrastructure to make new drugs. And I mean, that's just how we've structured research and development and drug discovery, which is my background, so it's kind of how I think, right? But again, I mean, if we're saying, what do we want out of a patent system? It's Pfizer saying, how can I invent a better vaccine to COVID? Whether it's a room full of pharmacologists or Claude, right? I mean, we shouldn't really care about that. We should be agnostic to how the invention's made, just what's most efficient for society getting invention. And so if we say, well, you can only get a patent if you use people, that's a major disincentive for using AI, or using too much AI, or all these companies that are saying we're building AI to invent drugs like isomorphic in London, right? I mean, you're kind of saying, well, if you need a patent, you can't really do that, or you're running a big risk doing it. And then again, most of the financial resources aren't in the invention, it's in commercialization. So in drug discovery, inventing a drug often is kind of the cheap part. It's running these massive clinical trials. And if you don't have a patent, most drug companies would say you can't run a massive clinical trial and get a drug approved and get new drugs in patient hands. So to me, the incentives work quite well. And for what it's worth, 6 years ago, the two most common thoughts I got were, A, this is stupid, no AI could invent something. And really, no one thinks that anymore. And two, yeah, you wouldn't want to patent this sort of thing. And I now find that attitude's gone from a majority to a minority perspective on it. As I think generative AI's public use has kind of changed attitudes about this.
Yeah, no, I can see that, and I can see that there's a natural fit for AI as a tool in the inventive process. But I suppose, you have chosen to pitch the battle as a question of inventorship. So that was the angle from which I'm raising the question of incentives. But
I think the cases were always about subsistence.
Okay.
But inventorship was kind of the path to subsistence, because the question was, can you patent something invented by an AI, right? And that could just be by not naming an AI, by naming something else. But the case was kind of saying, look, this is what happened. Can we get a patent? And we tried that different ways in different jurisdictions. In Germany, again, for instance, we had 5 alternate arguments. Name the AI, name nobody, name the AI plus the human owner of the AI, name the human owner of the AI. And eventually they said, all right, well, human, whatever, knock yourself out.
Okay, great. Thank you. So, Christoph, can I bring you in on this? I mean, I do want to go to the Supreme Court decision in emotional perception, but I think we'll do that at a later stage. If you could react to what you've heard so far and give us your thoughts, we'll circle back to the UK Supreme Court decision later.
Sure.
Thank you.
Sure. Yeah, no, this is a fascinating discussion. I'm very happy to be here and to hear a little bit more. I mean, obviously the DABUS cases have been at the
legendary.
Legendary. I mean, they have been definitely discussed and noticed. I'm originally from Germany, but I've been in Japan for quite a long time, and so I've seen the German decision, and I've seen the Japanese IP High Court decision that came down last year, and how the local community reacted. Reacting to some of the things I've heard, so I think initially we talked about whether or not AI can invent, and the question remains, what exactly does that mean? If the threshold is that AI should just spit out an idea, I think we all know that AI is pretty good at doing that, coming up with ideas with abstract concepts that then would need to be explored further. And I mean, that also is one of the main differences between AI, thinking about patent protection for what comes out of AI versus thinking about copyright protection for what comes out of AI. I mean, in copyright law, you need the exact expression. So I think it's more difficult to argue for the protection of AI-generated copyright works by copyright protection, by copyright law, than it is to think about, and I'm kind of like actually in line with my co-panelists here, thinking that if AI is a tool and there's a human that controls the tool, then what's wrong with giving that human patent on what comes out of that process? A key thing, of course, is, well, to which degree and what level of oversight does that person need to have? But that also doesn't seem to be so much of an inventorship question to me. I mean, that's something that then translates into the quality of the patent application, and then other patentability requirements become relevant. And not so much the question of who will be named as an inventor. I agree with Ryan that inventorship is very much not very harmonized, even though a lot of other questions or aspects of patent law have been harmonized through treaties and other instruments, and inventorship not that much. And I think what the DABUS cases did, that they did expose some of the acts of inventorship. Again, I mean, I don't think that that's necessarily something that companies cannot work around or cannot work with. I mean, we're talking about typically, I mean, both of my co-panelists say that anyway, patent law is done to incentivize corporations to invest in inventing and into innovation. Then that is probably true, but then we can also recognize that corporations have the resources to figure out the inventorship rules in different jurisdictions and make sure that they name the people that they think they have to name, including sufficiently to pass muster in US litigation if it comes down to that. Yeah, I think that's kind of like what I initially had to say. I mean, it's just, well, I think everybody in the room is also on board with recognizing that we need, well, I mean, the patent system exists to award or to reward humans to invent, and that is something that different courts in different countries clarified and affirmed, so as far as inventorship is. AI inventing things is concerned. I think as long as we have a human controlling the process or overseeing the process, that is the new reality.
Christoph, do you see any role for the trilateral office to come out with new guidelines on this, to harmonize practice on this? And if it does, is it going to go, which direction do you think it's going to go?
Trilateral as
the Japanese, the European Patent Office, the US Patent Office. They have in the past, had these exercises of harmonization.
They have, and I mean, they expanded the group in a way. They might include the Chinese Patent Office, or they might include, or WIPO might have. So there are different players that could come up with things. I mean, as mentioned earlier, I mean, so the Patent Office in the US had this exercise of, producing a very detailed guidance. But guidance by the US Patent Office, I think, means something very different than guidance by the EPO or guidance by the JPO. I think in the US it means the least. In Japan it means more, because there's more belief in administrative guidance, but it's still subject to court review, of course. And then in Europe it probably means the most, because the EPO is the god. And can't be really questioned too much. So I mean, certainly, I mean, that might be good to have some international collaboration and harmonization, but what it would mean on a national level is very different then.
Yeah, great, thank you. I feel like we've done sort of the first phase of what we set out to do. Shall we take some questions and then come back to the Supreme Court decision? I feel like this might be a good point to see if there are any questions in the room. Andrew.
Thank you. I actually don't have so much a question as a slight provocation, because the panel are all getting on rather too well. Apart from she was trying her best to prod. So the provocation is slightly. I'm agreeing with the Supreme Court, the UK Supreme Court, in one aspect here, and disagreeing with something that Ryan said, and I want to just get the panel's view on this. So, Ryan, you said the question was, can you patent something invented by AI? And I think you're asking the wrong question. I think the question should be, ought you patent something invented by AI. So what that does is it changes it from being a law question, which you're taking to the courts, to being a policy question, which the Supreme Court told you should take to Parliament. So the provocation is this not an inflection point where the law needs to be changed? This is a law reform question rather than an application of the law question. Aren't you knocking on the wrong door? Shouldn't you be before the Law Commission, trying to get them interested, getting parliamentarians interested, trying to actually say the law is out of date, let's bring the law up to date in a really measured way that involves lots of stakeholders rather than just judges?
Well, I like the question, unfortunately, so it's not quite as provocative as you might have been hoping it was. But, you know, this was done kind of in that spirit for two reasons. One, I don't know anyone in Parliament particularly well, so it's not like I had a door to go knock on. And B, this was done in the spirit of advocacy work, right? And very much academic advocacy work. This was all done pro bono because I wrote a law review article I thought was interesting. And people seemed to think it was interesting. And to change the law, I think the law did have to be clarified. Like, can you, before you say ought you, and they said, well, if you don't like it, go change the law. I thought we had a pretty good case, actually, for saying under existing law, there's a purposive interpretation that lets this happen. And we got away with that a little bit in a couple places, and we'll see in Asia, there's still, you know, this is still in China, it's still in Japan, it's being appealed to the Supreme Court, which is probably unlikely as it's a civil law jurisdiction. India hasn't even looked at it, but lots of people have said, India is very flexible about this sort of thing, we'll let this in. But yeah, I mean, this may be the next step in someone saying we should change the law. You know, after this, I got to speak at a US Senate hearing on the topic, and you know, now people are kind of talking about it. So it's interesting. I still think, and Brazil has introduced a bill to change the law on this now. I still think this case is ahead of its time in the sense that with copyright, now everyone gets this idea of copyrighting something out of an AI. And whereas 3 years ago, people thought the idea was terrible and that AI art was destroying humanity, now all day long people are asking me like, what do you mean I can't copyright something I had Claude make? Like, I made this, like, why wouldn't I own it, right? And so now this is like a thing. In patents, like, for law people it's a thing, but for the public it's not a thing yet. Like, they don't get like AI inventing stuff. So for policymakers, I don't really think it's a thing yet either. And it's also kind of hard to get them to do patent law stuff. At the Senate hearing, all the senators said we've never had such a crowded patent law session. Normally you can't fill the room, and it was out the door because it was patents and AI, and everyone wanted to talk about AI. But yeah, I do think that is the next step. Now that you largely, now that it's disharmonized, or here you can't do it, you know, should the law change, like with copyright and CDPA, you know, 9.3? And I would submit that yes, it should, and that's phase 2. And if you have anyone who wants to fund that, let me know.
You want to come in on
Well, I just say, I mean, just to pick up on what Ryan was saying, you need to get this to the top of the legislative agenda. And then when you talk about also seeking harmonization, not only does it need to become top of mind here, it needs to become top of mind, especially in the United States, if you're going to get harmonization. You know, look at the front pages the last couple of days, that's going to be quite a challenge. And so, I mean, this was the obvious first route. It was, you know, ask the courts, where do we stand right now? And then the courts told us, okay, should we reform? Yes. Good luck getting this to the top of the agenda.
Christoph, do you?
Yeah, I mean, maybe from the Japanese perspective, I mean, because that's something that happens a lot in Japan, that people don't take their cause to the court, but they try to get it into the legislative agenda. And that's what commentators in Japan also said, commenting on the IP High Court decision that was relying on Article 29 of the Japanese Patent Act, that says that an invention goes to the person that invents, and that needs to be a human. Well, the Patent Act should make different accommodations, then that shouldn't be through the court system, but then somebody should get MITI or the Patent Office that runs as an executive agency the initiatives that would then end up as draft bills and go through the diet. So as long as you get the people, the right people at the Patent Office interested, well, then that might be the more promising, the only promising route in that case. I think, well, your question also exposes the complexity of how the process would go in different parts of the world as far as law change is concerned. I think that is a very different process with very different dynamics in different parts of the world.
Also sounds partly like a job for WIPO, in part at least.
Possibly. I mean, I can, I think that's a really good question, and a question that deserves a sort of measured, resources to be thrown at that question. But with due respect to the DABUS project, I do feel like the inventorship question is the least interesting question. And the reason I say this is because unlike copyright, what we have with patent law is a system where you open up the black box of creativity. You've got the person skilled in the art, you've got variations of the inventive step standard, you've got common general knowledge, you've got a difference in prior art between novelty and inventive step. And what all of these different legal standards show us is an incredible insight into the inventive process. And for me, I think the interesting legal questions are in how these standards are going to be modified. Now, potentially there are many sleepless nights involved in trying to figure out whether the person skilled in the art standard will have to change with AI. I think that's an incredibly interesting question.
I did write a law review article on that also.
Yeah, and there's also the question of let's say the inventing machine, whether it's in the public domain or not, would make a big difference. Whether it was a proprietary machine, this, as in your case, is quite a different situation from things like Claude or ChatGPT, where some of this stuff is in the public domain. So to my mind, yes to making this a law reform question, but I would want attention to go to slightly more technical. I think that's where the meat of the inventive step process, lies. Yeah, Luke.
Yeah, thanks to the panel for a fascinating discussion. It's very interesting, thinking about this from a copyright point of view and then from a patent point of view, how under-realized the concept of inventorship is in patent law in comparison to authorship. Is something that comes to mind here. I mean, just to kind of be contrary to be a contrarian against my deed, maybe we don't need reform here at all because there isn't really a problem. There isn't really a problem yet, right? So, reading the UK cases on Thaler, I really got the sense that the court, particularly the Court of Appeal, did not like the idea that this was a test case. Colin Burris in particular, the way he responded to it.
I thought Colin was a big fan of ours and helped us out a lot. In fact, I was on a panel with him just after this where he said, this isn't the first AI invention I've had. Several years ago, he had a case where a component in a car had been developed by an AI. But no one was fighting over subsistence, but everyone agreed an AI had just come up with a thing.
Well, that's, I think, exactly the point that I want to get to, which is that what is the risk of any of these patents being attacked on the basis of subsistence, and who would be the one attacking them? In the sense that, we know going back decades that algorithmic processes have been used in drug discovery. So really what we're talking about here is something much more like a spectrum, going all the way back to mechanized tools. And the question is, at what point is the human using this as a tool, and at what point are we beyond that threshold? And in the copyright context, we've had the German case that maybe Christoph might want to say something just a couple of weeks ago, saying that a prompt is not enough to give you copyright in a logo. So we know that now under German law. But we had so little information on that.
Well, it's like a first instance case, right?
And it's just a first instance lower court case, right? But if you go back 10, 15, 20 years, animators using CGI were already doing prompts, and then most of it was actually being created by the machine, right? So, we're talking about a kind of a spectrum of creativity, a spectrum of invention. And at this point, if we draw the line too sharply, we may undermine a lot of the kind of prior, what drug companies are doing right now, what animation studios are doing right now. So it may actually be better to let this play out in the courts when there are attacks on subsistence that have real stakes to see how these things come out. Because the stakes of the Thaler case were incredibly low in terms of what he really wanted to get out of it in terms of the patent. So we haven't, and the recent logo case in Germany as well was a super low stakes kind of case. So I think we'll only really get to the answer of this when we get to something that's at really high stakes. That's my sense.
Well, right, this is the theory, you let the technology go for a long time and then the law creates a new rule and then, people may be like, well, we really shouldn't have designed our system that way if we're not gonna get protection. I mean, this case was an opportunity to kind of show what the rules were as people were building systems to animate or design drugs and what they needed to do to get protection or not, depending on how important it was for them. Richard Arnold and I have spoken several times about the case, and I thought he was kind of tickled by it being a test case, and he even cited my book in the opinion. But I mean, you're right, it is low case, but it also works very differently in the US than in the UK, because in the US, this would, people said, well, why hasn't there been a case on this if it's important? And I said, well, no one would proactively disclose this. You might lose your patent. But in the US, it would come up in litigation, like I mentioned, in which case, if we go 10 years and Pfizer loses a major patent because they've licensed a machine learning model, and suddenly every drug company says, well, the way we've been using computers, the way we've been using computers for 10 years makes our whole portfolio vulnerable,
How long was it hearing? How long was it hearing?
Oh,
30 minutes.
you wouldn't want an industry to say, well, we've kind of designed our systems wrong all this time, all our IP is vulnerable. I think you want the answer to it sooner than that. And it's a good example of where this has come up as a disaster, has been in the input side of copyright on the training question. It should not be the case you have $50 billion class action lawsuits in the United States right now about whether it's fair use or not to train AI systems on copyright protected content. I mean, there should have been a clear answer to this, like 10 years ago. And you knew it was coming for a long time, and there's still no answer. And meanwhile, businesses are like, well, do we use these systems or not? Do we train this way or do we not? My 2 cents while I have some voice left.
Sure. Well, just if I come back very briefly, I agree. It's a fascinating intellectual exercise, and I like the fact that you did it. But as I said, I'm still not entirely clear. For example, I see this it's very rare, for example, in copyright for anybody to challenge. For example, under U.S. law, if you're a U.S. composer or songwriter, you still have to register your copyright. It's incredibly rare for anyone to actually challenge the validity of someone's composition at the kind of registration stage. In infringement actions, it's more a question of, is it too similar? That tends to be the crucial thing, rather than the validity of the registration in itself. Because generally songwriters don't want to go around challenging and breaking apart each other's copyrights, because then that it would happen to them as well. So I mean, in the case of Pfizer, for example, I can't see any of the other pharmaceutical companies wanting to challenge on the basis of the argument you've made, because they're all using these processes. And so it would make them all incredibly vulnerable to challenge where they do.
I would disagree with that. I think when you get into litigation like this, it's no holds bars, and inventorship is very frequently challenged. It's always kind of a basis of challenge.
But not on the basis of AI, right?
Well, that's because it hasn't been a commercial thing yet at this level. So it's just becoming that way. So let's take the copyright example. There have been like really no cases on CDPA 9.3, right, on computer-generated works in the UK. And I think the reason for this is just like all the computer-generated stuff has sucked
up until like this year, right? This year, someone's going to have an AI make something that could make a lot of money, right? Like you can have it make music, but the music kind of sucked. Like now, what if I have it make a song that's streaming on Spotify and making a fortune? I mean, now there's going to start being commercial litigation over this. I mean, until now, who would have challenged this?
Well, going back to the patent thing, as I said, we've had this for decades already with algorithmic. I mean, if it was a solid ground to challenge a patent on the basis that algorithmic processing was used, surely one of these companies would have made that argument, but they haven't. And so, I mean, I still think it's a fascinating test case, and I agree with you doing it, but I do think you're exaggerating slightly the risk of the subsistence problem, given that, you know, given what your own argument is, this should have been vulnerable more than a decade ago in the commercial sector, and these arguments should have been made. And if it was so useful to make the argument, I think it would have been made in US litigation. So I think we're still some way off, and maybe we'll never get to the point where companies want to make that argument, because as I say, they're all using the same kinds of technologies to get where they want to go.
I take the point. I just, one final comment. A lot of litigation that would also be between generics and originator companies, where the generics are trying to invalidate. I mean, a lot of what I'm talking about is that, right? The generics want to get rid of all the originator patents. So, you know, there they would have these opportunities. But I take the point.
Great. Do we have any other questions on this part of the conversation? Yeah.
I do come from a civil law country, so I would like to make a question. Where is the new frontier? Because if AI is able to obtain patents, then who will be the owner of the patent? The owner of the machine? Or should we expect that in the near future we are going to have some sort of a legal entity that owns the patent that is different from the owner of the machine? Remember that we didn't have legal entities 300 years ago. So are we approaching a situation where we are going to have some sort of a legal entity that can eventually own the patent and exploit the patent, given the fact that the machine is able to think?
I suppose, I mean, if I was to slightly rephrase that question, in your ideal case scenario, if the judgment had gone the other way, you know,
What is the trajectory for this development?
what do you, if the Supreme Court had decided the other way, where do you see us in about 10 years' time?
Yeah, well, I mean, so, right. No one was arguing that an AI would own a patent, although we could get to the future in a moment. But, I mean, for the moment, you know, who would own the patent? I mean, the person using it, the person who developed it, the person who owns it. You know, there were some reasons to support all those. We went with the owner as consistent with kind of common law principles, and we thought kind of the incentives worked out best that way. And different parties could work out different arrangements by contract. So if you were using Claude to invent something, maybe Claude would say, we own everything Claude makes, or we'll license you an enterprise license and you own what it makes. You know, as to the idea of AI owning something, I mean, you could make an AI a legal person. I mean, there's lots of legal persons who aren't natural persons who own things, and we do that because we think it kind of has better consequentialist outcomes for people. And I've yet to hear a good reason to make an AI a legal person. I mean, you could do it, but it would be very complicated, and there's lots of problems with it, like how would it, you know, exploit a patent? And where would the benefits of that flow? And how would that benefit people? It's like saying, well, a Tesla self-driving car could be a legal person, but like, why not just make Tesla liable for self-driving accidents? So legally, the idea of, you know, an AI legal person isn't such a huge departure doctrinally. It just, I don't see a good reason for it. And if we're getting to AI that, as Elon Musk says, in a decade will so dramatically exceed any human capability we couldn't understand it. And Elon Musk says lots and lots of things.
patents are probably going to be the least of our interests. But everything will be obvious to a super intelligent AI, so we really won't have patents anyway.
Awesome. I like that. Do you want to comment on that question?
Well, I mean, people have these conversations, but I mean, like, what's going to be the future of IP in the remaining parts of this century, which will still go on for a couple of decades. I would again agree with Ryan that it seems not that necessary to think about AI becoming a legal person and then owning things. I mean, I think the pros of that doesn't really seem particularly compelling at this point. I think you're also trying to get us a little bit, nudging us into the discussion on non-obviousness or inventive step standards. But as far as I feel that, and maybe that's because we're just too conventionalist in our approaches, I feel that most people, the majority of the IP law academia, seems to be pretty okay with the tools we have at this point, and just thinks that refining these tools will be probably okay to keep the systems going. So on the non-obviousness inquiry, yeah, I think one can easily come to the conclusion that if inventors or oppositors or patent examiners have a lot more tools at their disposal, then the standard should be higher. Yeah, I think that's pretty clear, right?
Obvious to try standard would change.
Well, and actually, maybe this is it's the case that we should be exploring that a bit more urgently, rather than, as Ryan was saying, things that should have been settled a decade ago. 10 years from now, are we going to be looking back and saying, we really should have pursued that a bit further with more vigor at the time, rather than waiting for the reality?
Just to add to that, again, going back to, you're entirely right, Ryan, what you said, but going back to this is more, to me, a law reform project. Looks just wrong, than a kind of law exploration project. It is exactly around that. What do we mean by non-obvious when AI follows a different way of thinking than human thinking is? Our entire library is based on the idea of what is obvious and not obvious to a human inventor. But if you give an AI a problem, it will think about it in a different way to a human inventor. So it becomes very difficult to say what is obvious and non-obvious when you're using that tool as to when you're a human inventor working with a desk tool, essentially. So I think we do need to think about what do we mean by non-obvious. Do we need to change the standard if what we're doing is using this tool to attack problems from a different direction?
I think I think that's an excellent point. I think
if I was to develop that further, I would say then what is the need of the hour is that we move beyond simple fulfillment of non-obviousness and take it into the material world and say you need to disclose your best mode of production, or you need to evidence how this actually solves the problem, that it's not this sort of generic abstraction that is presented, and therefore that might provide us with certain other directions of reform. I will leave that part of the discussion there, and because I have such an excellent panel, I do want to talk a little bit about emotional perception AI, and what I will do is I will try to sum up the case as best as I can and then leave it to you to develop on that. So initially when I started teaching patents at LSE, I had invited Robin Jacob to speak about software and computer programs as such. And he gave a wonderful seminar, at the end of which he said, I am so pleased that as Court of Appeal judge, I have not been asked to decide on a software case. And of course, 6 months later, he was giving Aerotel. And now, I'm thinking a lot about Robin Jacob and how he must be feeling, given that the Supreme Court has now said there's no need to use Aerotel, and any hardware approach is the right approach to use in the UK. So just very briefly, the facts are an invention that is an artificial neural network that mimics how the brain works, which is not connected to any particular kind of hardware. It can be connected to multiple kinds of hardware. So the question was whether this is a computer program and therefore cannot be patented, right? So the court seems to say quite a lot of different things. And one thing that struck me is, we've kind of gone from Turing's universal computer to
a form of universal program that can attach to any hardware. And the court is saying it doesn't matter that it's not actually attached to any hardware. We will send it back to the hearing officer to see whether anything changes if it is attached to hardware. That seemed to me quite striking. And of course, there are two other sort of institutional concerns here, which is that the Supreme Court seems very persuaded to follow the EPO's jurisprudence without giving much attention to the fact that when it comes to infringement, it's national courts that will have to deal with this question, whereas the EPO does not need to concern itself with the question of infringement. So to make this purely a question of harmonization, when the function of the courts in this country goes beyond what the function of the EPO is, seems to me perhaps a blind spot. And the last point I'd make here is this any hardware approach, has finally killed the subject matter eligibility question in patent law. So this particular part. I suppose there's another sort of related question to that. It seems to me that it would have been open to the court to follow a Symbian kind of approach and say that this is an example where we have a technical effect without hardware, and we can decide that on that basis without having to completely trash error 10. So there's a few thoughts here. If you want to pick up one or two of those and respond, that would be fantastic. Shall we start with you, Robert?
Well, as we were discussing earlier, just before the talk, the key aspect to me of the court's decision was, that harmonization being a goal of the legislation.
Yeah.
And ultimately, I think from a commercial perspective, certainly, harmonization is good. Right? Business wants certainty, and if you have the same approach, or nominally the same approach, we don't know how it's going to shake out yet in the UK as you would in the EU, then broadly I think that's probably likely to be quite welcome. The points, the concerns you raise, I think are valid, but I think we're not going to know really whether the court made the correct decision, or ought perhaps to have gone further in nudging the UK IPO in the direction that they're hoping they go. That time will tell. We may end up, who knows, we could end up with a flood of litigation now. This could end, the results of this may well end up in the courts. And so we'll see, and then there will be a period of argument over the post-Aerotel position, how the examiner ought to have applied it, something it got through which ought not to have gotten through, even though the court says it's on the bar.
So you're not laying your cards on the table?
And I am not, absolutely not. Again, fortunately, I am not a patent attorney, and so I do not spend my days concerned with whether or not I have adequately specified a technical effect in an application. But yeah, it's an interesting decision. It's obviously going to be consequential, but I think we'll have to see exactly where all the chips land.
Great, thank you. Christoph.
So I think one point that you made, I don't think that is really so much of an issue, is the role of the EPO in infringement directions. Because you're right, of course. The EPO is not to be concerned with patent infringement. That is a question for the various courts in the various jurisdictions. But if I understand the UK case correct, it's also not really an infringement case. It's about patentability.
But potentially what it says will have an impact on infringement cases.
Of course. Whatever the scope and the threshold for getting a patent that will be potentially then lead to patents that will potentially be litigated. But then that's the infringement test. That's something that the courts can develop. But as far as what European patents is the patentability process, the prosecution stage is concerned, the members of the European Patent Convention decided many, many years ago that the EPO should be set up in the way it's set up and should make decisions in the way it makes decisions. And as I mentioned earlier briefly, that makes the European Patent Office the king of patents in all member states of the European Patent Convention. and that includes the United Kingdom. So if the United Kingdom Supreme Court chooses to endorse whatever the EPO is doing, that seems sensible.
But it hasn't always been the case for UK courts. UK courts have held out quite strong, quite substantively for quite a long time. So it feels like a pivot.
Yeah, no, but I mean, I think, well, so UK courts have done their thing. German courts not so much so, right?
Yeah.
So the German Bundesgerichtshof that does hear patentability cases, I think has been less inclined to go different routes than the European Patent Office. It has at times, but maybe in a more nuanced approach, in a more nuanced way. Well, one can think whether the current EPO setup is the right one. I mean, the fact that, the UPC system got delayed by a few years, not just because the UK chose to leave the European Union, but also because the German courts were quite at unease about the appeals procedure in the European Patent Office and the fact that there's not really a court reviewing whatever the EPO is doing. But I mean, that's the system that we have in Europe at this point. If the UK courts say, well, yeah, we tag onto that one, then that doesn't seem to be a terribly bad idea in light of the system as it is.
So you see it as a pragmatic move.
Yeah.
Fine.
I'm not sure I have anything I can add to that, plus I've dominated the DABUS discussion to date. Did you have was there any specific input you were looking for at this point?
I suppose the question is, if you are moving towards greater levels of abstraction, particularly with AI-led inventions, where does that leave the subject matter eligibility question?
I mean, I can say, from a US perspective, because, this has been going on there, as long as it's been going on here, this has remained kind of a fiercely contentious area. The Supreme Court hasn't weighed in on it since, Alice. Every year there's proposals for legislative reform. An act was just proposed to kind of get rid of all subject matter, effectively get rid of all subject matter eligibility challenges to AI-based, computer-implemented inventions, as you call them here, or software patents, as they're sometimes referred to there. And so, on both sides of the pond, this remains a highly contentious issue. And the US standard right now is kind of the Alice Mayo two-step test, where you look to see if it's just an abstract idea, if there's more than that, if the exception follows the rule. But it remains a very contentious, litigated issue that AI is supercharging, and also on the legislative agenda.
It also makes me think that the UK Supreme Court is behaving a little bit more like the US Supreme Court, that it does not hesitate to wade in occasionally and upend settled law, which I think the US Supreme Court has been very, it's been known to do. And it feels like the UK Supreme Court has also entered the sort of brave new world where it is not going to hesitate to pull things down. Any questions on that or anything else that we've discussed? Yeah.
Another question. What do you think is going to happen at the multilateral level? I mean, you obtain a patent in the US. Do you think that you can also, because of the use of a multilateral convention, you can use that patent, the US patent registration in countries like, say, Colombia? The conventions should work.
My prediction is nothing for a long time. So WIPO has been a forum for stakeholder discussions. They're now on WIPO conversation. I've lost track, like 19 or 20 or 24 or something. I mean, to start, no jurisdiction knows what it wants to do right now. It's going to take a long time for them to even figure this out, but I was kind of there for some of the earlier WIPO conversations, so they'd had enough of what I thought. But really, I mean, the US was kind of against this, and then they were for it. But I mean, if you wanted to have a jurisdiction that should be pro-AI patent, or like pro-AI generated invention patents, you'd think that'd be the United States. But they have not yet been that way. It may be that eventually they come around to decide, given we've got kind of all the AI companies and the models based here, we probably really want to push this on the developing world, and we want to make this part of, the multilateral framework. But they haven't done that. some actually, the biggest supporters of AI-generated patents have been in the South, like with Brazil, you know, not necessarily that one bill, but there's been a lot of support for it. Another interesting fixture, at least on the copyright front that may go to the patent front, is historically people thought, well, one reason not to protect this stuff would be that if you could have AI invent really well, Google would own all the patents in the world because they'd have the models. But in copyright, what's actually happened is you kind of diminish the north-south divide because they've made the models freely available to everyone. And so you don't need to be a music or a movie studio anymore to make creative stuff in the way that only they used to be able to make it. And now kind of everyone everywhere can use AI to be creative. So it's not so clear that it is really going to be a developed country play for AI-generated inventions, but you know, we'll see. And in the meantime, I don't think anyone at these conversations kind of has much of a mandate to do much, and it's a difficult time for multilateralism.
Yeah.
But we'll see.
We've noticed this is a difficult time. That's great, fantastic. Any final questions? If not, I have one for all of the panel. Yeah?
I can just add one thing to your point, Shiva, about the UK Supreme Court and the harmonization point about the EPO. So in 2017, the UK Supreme Court brought in the doctrine of equivalence. And when they did that, the court was quite clear that they thought the UK should be following the EPO on all matters of patent law. So it's not a surprise, actually, that they've now done this. They telegraphed this a while ago. And the old guard of Lord Hoffman and Robin Jacob were completely against it, but the new guard very much thought harmonization is the way to go. And there's another thing to add to that Christoph might know a little bit about. I need to get more into the weeds on it, but the UPC has also been using long-arm jurisdiction to grab some patents that aren't necessarily
enforcing.
Yeah, exactly. And there you can deal with infringement and validity, and it's meant to follow the EPO on validity, but create its own infringement law. So there may be some reasons to be concerned along the lines in terms of what the UPC might do with patents granted in that way.
Some additional play there via the EPC, for sure. And I agree with you on the UK Supreme Court. I mean, I think we had a really good first look with Human Genome Sciences versus Eli Lilly, where for an industrial application case, the UK Supreme Court says, we don't know, we can't go with US jurisprudence, and then they look at EPO jurisprudence and extract 15 different principles that all follow from US law. But they don't inquire about the provenance of those 15 principles, but they just sort of take it on wholesale, if you like. So yeah, we have seen a preview of this, but I think institutionally it does raise some important questions about what the national courts are losing when they are following what is practically a quasi-judicial administrative body that has no independent judicial oversight, which is the European Patent Office. Okay, with that, I'm going to take one last shot at engaging my three panelists here with one question that I want to pose to all three of you. Given the moment we are in, what do you think, for intellectual property, not life in general, but for intellectual property, what do you think AI brings that is least desirable and most desirable? About a minute each, please.
Ooh. I mean, least desirable, I would say, I think that maybe the curbing of human creativity in the sense that rapidity of production and output is being favored over the time that really ought to go into the creative process. And this came to mind actually when Andrew was making a point that AI it thinks differently than we do, but I think crucially, it thinks almost instantaneously compared to us, right? The inventive process for a human inventor can take a long time. And AI can process all of that. Now, it will take a lot of water and energy for us, but very quickly. And so that to me, translated, I guess I'm thinking especially in the copyright sort of sense, just sort of the cheapening, I guess, of the human creative process, the artistic process, I think is the least desirable. And also, obviously, the debasing of human creative output. I mean, I think the wholesale copying is a problem. The best thing, I think, democratizing potential. I think the ability for people, as Ryan was saying, in the developing world, to have access to exactly the same tools at exactly the same time that those in the developing world have, fantastic. I mean, I think it will absolutely help creativity flourish in those parts of the world. Now, no doubt there will also be massive downsides, possibly environmental, certainly, when it comes to AI, because it's a very inefficient way of processing data. But yeah, I think there's a huge democratizing potential there. Maybe even on the inventive side, actually. You know, maybe you don't always need a huge corporation and the financial backing, or to be independently wealthy. Maybe you can just be curious and, you know, inclined in a certain scientific domain, and with access to the right AI tools, you can be the next, you know, billionaire inventor.
I think that's two upsides. So, thank you.
Upside. What I like about the advent of AI, of generative AI, is that it sheds new light on a lot of elements of copyright law that have been taken for granted for a long time. And I personally feel, I'm not a copyright law scholar, and maybe that's why I feel that copyright law kind of like sits at makes a lot of wrong assumptions, so that has developed in a way that seems not particularly well aligned with other areas of intellectual property law.
So you see the re-questioning, the rethinking of this as a positive?
As a positive thing, yes. Negative. Well, I think AI also has the, and I'm not sure it's really a negative thing, but we talked about inventive step standards, non-obviousness standards, a little bit today, not much. But if you expand that a little bit, and you realize that AI could produce vast libraries of prior art, and people in patent disputes could deliberately pick this or that or this piece of prior art, and I mean, if you think that through, that essentially would potentially invalidate pretty much all patents.
So we would have to re-examine absolute novelty as a...
Yeah, I mean, so I mean, again, is it a negative thing? I'm not sure, but it's a very consequential thing, and maybe it just exposes that I like patents more than copyrights.
Perfect. Yeah. And Ryan, before I give you the last word, just to say, I did, you know, you've done all of this pro bono. You started from a standing start, and now you've raised this conversation in multiple jurisdictions, and it is a conversation that will carry on, right? And you have started something that has quite a long shelf life. So I would like to congratulate you on, you know, starting this amazing conversation, and I just feel I think this is going to be the conversation that we have in intellectual property, for good or for bad, for many, many years to come. So, and you have the last word.
Well, that is very kind and generous of you, and my least favorite part of all this was doing it pro bono, but, you know, there was something to be said for this. You know, for me, I think the best and the worst bit of this is if you play this out, you know, granted, Elon Musk and Sam Altman say a lot of stuff. But again, like when we started this 10 years ago, I had to give, like, the first half of the presentation was why I thought AI was going to matter to people eventually and why I thought it was interesting. And now all those slides are gone because everyone's talking about AI all the time. And, you know, people used to think, oh, AI is never going to be able to do the stuff it's doing right now, right? But I mean, AI is only getting better. People aren't only getting better. And the inevitable consequence of this is AI is going to be better than us at doing this stuff. And so for me, I think you know, the best and the worst bit of that are how we're going to deal with it as a society, right? Because AI making an unlimited amount of creative and inventive concept could be great because we get an unlimited amount of everything from cleaner energy to better drugs to like endless entertainment. And, you know, it may make much of what all of us are doing redundant, you know, or all of what we're doing redundant. And that works well if we have a system that is designed to let us all share in the benefits of that, and not if we have a system where the benefits all flow to 5 guys and the rest of us basically have nothing to do and no resources. And so I think kind of that is our challenge. How are we going to manage AI's ascendancy as a society?
Wonderful. I can't think of a better place to leave this conversation. Thank you very much for being here with us and giving so generously of your time and your thoughts. Thank you.